Hello, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about fishing licenses. Cases that should have gone to the Supreme Court of Canada, but didn't. Kirby Elson was prohibited by the Department of Fisheries and Oceans Canada from applying for or obtaining any fisheries license. The reason for this was that he was engaged in an agreement with a business that would allow him to essentially transfer the use of his license to the business, and the business could then use it for commercial fishing purposes. The Department of Fisheries and Oceans wanted to shut down Mr. Elson's ability to engage in this business practice, and so they revoked his fishing license and his ability to apply for future fishing licenses. Mr. Elson argued that essentially this was a violation of his rights because he had the right, once he held a fishing license, to engage in any type of business practice that he wanted. And what the government was effectively doing was collaterally regulating what type of businesses a person can engage in without any justification or right to do so, that they were unnecessarily and unjustly interfering in business practice. This case raises very important issues about how far government can go in passing regulations and enforcing administrative licensing schemes to prevent people from using their licenses certain ways. And it doesn't just have applicability to Mr. Elson's circumstances and the circumstances of fishing licenses, but any license issued by government. A firearms license could be revoked for somebody running a gun range. A driving license could be revoked for somebody running an unlawful Uber-type business without a permit. All of these things, it opens the door to government to take those actions and to eliminate people's ability to engage otherwise in regulated activity because they also want to pursue business opportunities associated with something that they're validly licensed to do otherwise. This has huge potential for government overreach, and the Supreme Court of Canada should have stepped in to put some limits on the ability of government to overreach, to interfere in private marketplace decisions that the government doesn't have any business in being involved in, other than perhaps tax collection. This is a circumstance where the Supreme Court of Canada again missed an opportunity to prevent mischief. And this case will raise important implications in the future in many licensing schemes as government becomes more heavily involved in the lives of private citizens and their private business arrangements. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but Didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Like, subscribe, and share with your friends.